Today we are going to be looking at the area of intentional torts and strict liability torts. If a victim can show that the defendant actually intended to commit a tort, instead of bringing an action in negligence, the plaintiff's claim can be pursued as an intentional tort. Thus, unlike with negligence, intent must be shown as regards committing the tortious act, if not the actual consequences of the act. Alternatively, if the victim is unable to establish either an intention or negligence as regards the act of the defendant, in certain limited circumstances, an action may be brought under the heading of strict liability. To succeed in an action under this heading, it is necessary to show that the harm resulted from the defendant possessing an element so dangerous that he is responsible for any resulting damage, despite the lack of intention or negligence on his part. Now let's look at the area of intentional torts. A plaintiff wishing to prove that the defendant committed an intentional tort must demonstrate 1. Intent and 2. Causation. Intent. It is necessary to show that the tortfeasor intended to commit the tort in question. It is not always necessary to show that the defendant intended the actual consequence, but that he intended to do the act. Causation. Unlike the tort of negligence, remoteness and causation play a far less important role in the case of intentional torts. Normally, it is necessary for the plaintiff to show that, but for the tortious act, the injury would not have occurred, i.e., the injury would not have occurred if the defendant had not acted in the way that he did. It is not necessary to show proximate cause, as in the case of negligence, i.e., that the act was the primary cause of the loss suffered. There are a number of different common law intentional torts. The first type of common law intentional tort is trespass to the person. Trespass to the person can take a number of different forms. The first is assault, and the second is battery. Assault. Assault is the tort of intentionally causing apprehension of an immediate, harmful, or offensive contact with another person, but where no physical contact occurs. For example, wielding a knife in front of a person, putting them in fear for their safety, but not actually hitting or stabbing them, will be construed as assault. Battery. Battery is the tort of intentionally hitting or causing offensive contact with a person or something closely related to them, like their hat. Unlike assault, battery involves actual physical contact with the other party. Obviously, both assault and battery are also offences under criminal law, and often an action based on one will naturally follow the other. The second type of intentional tort is false imprisonment. False imprisonment involves confining the victim to a place which they are prevented from leaving. In some common law jurisdictions, for example in the United States, there is an exception to the false imprisonment rule under what is known as the shopkeeper's privilege. Under this exception, a shopkeeper is allowed to detain a suspected shoplifter under a store property for a reasonable period of time in order to investigate whether they have stolen goods. The third type of intentional tort is the intentional infliction of emotional distress. IIED. The tort of intentional infliction of emotional distress was created to complement the tort of assault. This tort will occur where a person intentionally causes another emotional distress, provoking nervous shock as a result. This is not the easiest of torts to prove, as the courts are suspicious of trying to measure mental suffering in financial terms. Thus, in order to succeed in a claim under this heading, the behaviour complained of must be truly outrageous. For example, maliciously ringing a person to inform them that their spouse has died in a road accident. The fourth type of intentional tort is trespass to land. Trespass to land involves entering and or placing products on the land of another. For example, dumping rubbish in your neighbour's garden is an example of trespass to land. As volition to commit the tortious act must be present, no liability will attach in cases of sleepwalking. The fifth type of intentional tort is trespass to goods, or chattels. Trespass to goods involves the intentional interference with the goods of another. In order to establish liability under this heading of trespass to goods, it is first necessary for the plaintiff to demonstrate ownership of the goods in question. Thereafter, the plaintiff must show that the tortfeasor interfered with the goods. The area of trespass to goods is governed in the United Kingdom by the Torts Interference with Goods Act 1977. Where trespass to goods results in the goods being kept and used by another, the defendant may instead be the subject of an action in conversion. A classic example of conversion occurs when a person finds lost property of another and decides to keep it, rather than returning it to its owner. In such a case, one is clearly doing more than simply interfering with ownership, as is the case with trespass to goods. Conversion is also a crime under criminal law. Criminal conversion, i.e., defendant will be liable under both criminal and civil law. Criminal conversion can be distinguished from theft as there is no need to show intent to deprive the owner of possession of the goods in question. The sixth type of intentional tort is nuisance. Nuisance involves interference with a person's land or servitudes. Unlike trespass, which is actionable per se, in the case of nuisance, it is necessary to prove actual loss resulting from the nuisance in order to receive compensation. Nuisance can be divided into public nuisance and private nuisance. Public nuisance is an unlawful act or omission interfering with the safety or comfort of the general public. Private nuisance involves an act the scope of which has only limited effect. For example, a man allowing his dog to enter his neighbour's property, leading to the garden being damaged. The seventh type of intentional tort is defamation. Defamation is the general term used to describe the act of making untrue statements about others. Other terms exist to describe specific types of defamation, for example, calumny, libel, and slander. Calumny and slander are used for spoken, transient words, and libel for written, permanent words. The tort of false light also exists and involves the making of a statement which, although true, creates a false impression and was intentionally made with this purpose in mind. An action in false light exists to compensate people for damage to their feelings, emotional well-being, or dignity, as opposed to their reputation. Now let's look at the area of strict liability torts. In the case of strict liability torts, a person is held strictly responsible for what occurs, regardless of whether they have been negligent or intended to harm. To establish liability under this heading, it is necessary to demonstrate that the 1. Element was inherently dangerous, and 2. The defendant brought the element onto his property. In such circumstances, the defendant is deemed to keep the element at his own risk, for example, a loaded gun, and is considered strictly liable for any harm that results therefrom. Once these criteria are satisfied, the victim does not need to prove that the tortfeasor acted with intent or that he was negligent. Neither does it matter if the defendant took precautions regarding the dangerous element, or indeed that he had good faith intentions when acting in the way that he did. The defendant is considered strictly liable for any harm that results. As we have seen, strict liability is only applied to things or activities that are inherently dangerous, such as storing explosives, using hazardous materials, or keeping a vicious dog on one's property. Now finally, let's look at the different defences available in tort. As regards to torts of negligence and intentional torts, a number of different defences exist. The first is agreement. Perhaps the best defence to an allegation of tortious conduct is to demonstrate that the person indicated that they were in agreement with the behaviour in question. This defence is often referred to as volenti non fit injuria, i.e., no injury can be done to a willing person. The second type of defence is necessity. If the defendant can show that the behaviour complained of was necessary or unavoidable, then the complainant's action will not succeed. For example, if a person trespasses on another's land to avoid a danger such as a wild bull. The third type of defence is mistake. Although as a general rule mistake is not considered a defence in law, where the mistake in question is reasonable, the courts may be willing to accept the defendant's plea on these grounds. The fourth is self-defense. At all times, a person is entitled to use reasonable force to defend themselves against unwarranted attacks, whether intentional or non-intentional. And the fifth type of defense is statutory authority. Frequently, statutes may authorize either a government agency or a private party or company to carry out works for the benefit of society in general. For example, the building of a public road. We hope you enjoyed this introduction to the area of intentional torts and strict liability torts.